This 20th anniversary for Concurrences is quite a landmark, I must say, and so much has happened in those 20 years in the competition world. Much of it, really, probably all of it, documented over the years by Concurrences. And so it's fitting to just take one slice of that and see, as an example, how much things have changed. It was just about 20 years ago that the courts in the U.S. Began implementing what one commentator described, I think correctly, as a fundamental paradigm shift in the standards applied to the analysis of class certification in antitrust litigation. Of course, class certification is the threshold issue when a class action has been filed and seeks certification so that the individual plaintiff can represent the entire class. The status quo before this change was that courts would just presume that class certification was appropriate in an antitrust case, leaving merits disputes to be resolved in due course, and declining to adjudicate disputes between experts as long as the plaintiff's expert's opinion on class certification was not fatally flawed. So that regime has been supplanted over these 20 years by a much more exacting inquiry that many of you will be familiar with. Starting really in 2000, early 2000s, when the Third Circuit clarified, or as it put it, that the decision to certify a class calls for findings by the court, not merely a threshold showing by a party that each requirement for class certification is met, but rather factual determinations made by preponderance of the evidence as to each of those. And the court has to, we were told, resolve all factual or legal disputes relevant to class certification, even if they overlap with the merits, including disputes touching on elements of the cause of action, and the court's obligation to consider all relevant evidence and arguments in the expert's testimony. So this shift over these last 20 years, in cases that, again, have been documented in Concurrences, has made economic analysis now central to even the earliest stage of antitrust litigation, often occasioning intense and contentious disputes, and many of which the fight is over whether questions of law or of fact are common to all the class members, a requirement for being a class, and whether or to what extent sampling can be used and a regression analysis is appropriate to prove this predominance requirement. So in 2016, so sort of halfway through the life of these 20 years, the Supreme Court in the U.S. said that sampling and regression analysis could be used in class certification, but that wasn't in an antitrust case. It was in a pension statute litigation, and the court rejected a categorical rule in favor of case-by-case determination and upheld the use of statistical evidence and sampling in that case. But now, whether this holding in that case was Tyson Foods against Bua Fakeo, whether that extends to competition cases is still unresolved in the U.S. But regardless of what happens as to that issue, the prominence of economic analysis is likely now a permanent feature, even at the class certification stage. So the result is we now have full-fledged economic analysis, economic disputes, evidence, and so on at the initial class certification stage, again at the merits stage, and finally at the remedy stage if the plaintiffs prevail. So the entire process over this 20-year period has gone from to be one that is now really dominated by expert economic testimony, economic issues, and sometimes daunting economic questions presented to be resolved by the courts. Many of us could rejoice at that, others could bemoan it, but that's pretty much where we are. These last 20 years have been ones of great change and turmoil in the class action arena, again, as documented in Concurrences, in the articles, and of course in the database. So it's been quite a ride for the publication these 20 years, and I'm very thankful for that.